Environmental activists have welcomed the court ruling to set aside for a review a decision by Mineral Resources to grant exploration rights to Shell to conduct a seismic survey off the Wild Coast. Now, the ruling was made at the Makhanda High Court in the Eastern Cape. Shell was granted rights to explore gas and oil in 2014. That decision was renewed in 2021. But civic organizations and environmentalists took the matter to court for review. Lawyers representing environmental activists say they are happy about the ruling, adding there was much anticipation leading into this court case and hailed the judgment as victory for the people of the Eastern Cape. All right, now let's get some reaction on this ruling. We are now joined via Zoom by Siqhamo Yamkela Ntola. He's a senior lecturer at UNISA's Department of Public, Constitutional and International Law. Thank you so much for joining us this afternoon. Now, a blow, of course, no doubt, dealt to Shell. Please unpack what this ruling means for the parties involved.
Well, thank you for having me on your show today. It is indeed a significant blow to Shell, but I think a great victory for the communities in the Eastern Cape, particularly those who are affected by the activities that would be directly undertaken off the Wild Coast. So, I mean, what's basically happened is that the judge has ruled today that, the decision to grant an exploration right by the Department of Mineral Resources to Shell has been unlawful, largely based on what I would consider grossly inadequate public participation process, which really didn't take into consideration a number of factors. One being that the mechanisms that are used, particularly in rural communities, to make these sorts of decisions and to adequately participate in what would be the environmental management program processes. So it's a significant victory, particularly when you consider the importance of protecting the environment, in light of having those same environments being beneficial, to communities in the near and distant future.
I was going to actually ask you in terms of, what the court said in terms of the validity of these rights being granted by the minister to Shell. I mean, we understand that they were granted these rights in 2014, then renewed in 2021. Do we have any indication in terms of, during this period, if at all, particularly if you look at the 2014, the granting of these rights in 2014, was there at all any engagement that was had with these communities?
Well, engagement in particular to the communities directly affected, and by this I mean the rural communities off the Wild Coast. So you're really looking at the Amadiba region in Eastern Bondoland, or what would be termed as Eastern Bondoland in the past. They, according to the judgment, which I recently read, were only really consulted or really became aware of the right that was granted in 2021, this despite it being granted, a couple of years earlier, which obviously spurred their desire to want to be heard with regards to this right. So I would submit that, the process which was undertaken was grossly inadequate. I think the judge lists the mechanisms that were used by Shell and the other parties involved in order to undertake such a process. And those mechanisms include things such as, the appropriate language with which you engage those members of the community, the fact that, information was made online and many of the people in those regions don't have electricity, let alone internet. And I think also importantly is that the mechanisms that are used in the community in order to engage on such aspects weren't involved. What instead happened is that, the parties that were granted the right went about consulting only with the chiefs and the kings or the monarchs in those regions in order to obtain the necessary consensus, to undertake that. And that's grossly inadequate when you consider that, particularly in that region, and in all other traditional regions, democracy is exercised as a bottom-up approach, meaning that, such decisions are discussed firstly at a grassroots level and then make their way up the hierarchy in order to be ratified by the powers in those traditional communities. So, the process that was undertaken, in my view, was grossly undemocratic, and failed to recognize the needs and the opinions and the uses, both as far as customary fishing rights is concerned, as well as spiritual aspects that come, with the oceans.
And, as you say, the court also, of course, unpacks a number of procedural flaws in its ruling. But they've also mentioned areas of concern as it specifically relates to Minister Gwede Mantashe. What does this say then about the strategy in as far as the legal team for Shell is concerned?
Well, look, it's very concerning in that sense, and and for me, when I read that part, it's difficult to imagine that the minister, is objective in his consideration when it comes to granting not only, a mining right or prospecting right or an exploration right, but also in considering the environmental aspects that are concerned. So it already appears that there's already a predetermined conclusion, when an application has been made. What the applicants had also emphasized in not only the first part, but the second part of the application was that, an environmental authorization ought to be undertaken, and implicit in that would be an environmental impact assessment, right? And that's a more comprehensive, robust aspect of such activities, because it really then allows us to make use of the best science to determine whether or not undertaking these activities would be viable, and whether or not the party that wants to, in presenting their own scientific evidence, would be able to take the sufficient measures to mitigate and curb environmental damage. But the problem with that in itself is that granting environmental authorizations, and the administrative process that ensues as a result is subject to the Department of the Minerals Department, which should actually be housed in the Department of Environmental Affairs, because they would arguably be more objective in those considerations versus the DMR.
Siqhamo, just explain to us then, the next steps in as far as Shell is concerned. They obviously saying that they're reviewing the judgment to determine next steps. What steps do they actually have?
Well, I would guess that, the next step that they would probably be considering is to appeal the judgment. I'm not quite aware on what basis they would do so, but I think, having briefly read the judgment this morning or just early this afternoon, I think they would find grounds in order to, have that judgment reviewed and take it to, a higher court than the High Court in the Eastern Cape. So presumably they would be heading to a full bench.
All right. Thank you so much for unpacking all of this for us. We really do appreciate your time. Siqhamo Yamkela Ntola is the senior lecturer at UNISA's Department of Public, Constitutional and International Law.